Verbal agreements, are they worth the paper they're written on? Well, technically, they're not written on any paper at all. But can you still take someone to small claims court over a verbal agreement? Let's find out. Verbal agreements can indeed be legally binding. However, they come with a catch. While they're valid in many situations, they're much harder to prove and enforce compared to written contracts. This is why many people are wary of relying solely on verbal agreements. The main challenge with verbal agreements is evidence. In a court of law, it often boils down to one person's word against another's. This is why courts typically prefer written contracts, especially for certain types of agreements. For a verbal agreement to be considered a valid contract, it must contain several key elements. There needs to be an offer made by one party and an acceptance of that offer by the other. Both parties must provide something of value, known as consideration. And there must be mutual assent, meaning both parties understand and agree to the terms. Now let's talk about the statute of frauds. This legal principle, adopted by most U.S. states, requires certain types of contracts to be in writing to be enforceable. These include real estate sales, leases longer than a year, agreements to pay someone else's debt, and contracts that take more than a year to complete. However, there are exceptions. If one party has partially performed their part of the agreement, or if someone has relied on the promise to their detriment, the court might still enforce the verbal agreement. So, can you take someone to small claims court over a verbal agreement? The answer is yes, but you'll need to bring strong evidence to support your claim. This could include witness testimony, any related documentation like emails or text messages, proof of payments, or evidence of actions taken based on the agreement. In small claims court, you'll need to file a claim detailing the verbal agreement and how it was breached. You'll present your evidence, and the other party will have a chance to defend themselves. The judge will then evaluate all the evidence and make a decision. To sum up, while verbal agreements can be legally binding, they're far from ideal. They're harder to prove, more challenging to enforce, and can easily lead to misunderstandings. If possible, always get important agreements in writing. It's the best way to protect yourself and ensure everyone is on the same page. Remember, a little paperwork now can save you a lot of headaches later.